Hi everyone, welcome to this Australia and New Zealand School of Government and National Regulators Community of Practice webinar on the topic of Guilty Corporate Minds, Old and New Approaches to Regulating Corporate Misconduct. Firstly, I would like to acknowledge the traditional owners of the lands upon which I'm hosting this webinar from, which for me is Meanjin, otherwise known as Brisbane, the traditional home of the Turrbal and Yagara peoples. I pay my respects to their elders past, present and emerging and honour their connection to the land, waterways and community. I'd also like to welcome you to this really interesting session centering on corporate culpability, which is truly a nebulous area for every regulator, and we deal with it a lot in our work in improving outcomes for consumers and citizens and markets in Australia, and certainly I've come across it quite a lot in my career so far. There are so many examples in the sectors we regulate of poor consumer outcomes resulting from overarching corporate behaviour made up of various individual employee acts that fit within a broader corporate agenda. There is often diffused responsibility that we find when we investigate these types of poor corporate conduct examples, and there's sometimes an absence of individual human fault, especially if information is siloed across a large organisation. Professor Elise Bant, who we've got here with us today as one of our panellists, has focused on a concept she terms systems intentionality, which is really interesting. It looks for the corporation's purpose objectively by reference to the broader systems and processes adopted and implemented by the corporation to achieve its ends as a rationale for corporate responsibility. It's going to be a really fascinating discussion today, and if any of your colleagues have missed out on the webinar, the session is being recorded and will be made available later for viewing on the website and our YouTube channel, along with the slides and resource materials. So I'll begin shortly by introducing our panellists to you, and then our panellists will each shortly present to us on the topic, giving us a bit of background and context. We will then move into discussion and questions before finishing with some final thoughts. So I encourage you to use the Q&A function during the webinar to ask any questions of our panellists that may be generated by the presentation and the discussion, and I'll be able to pick questions out of those Q&As that you pop up to ask them. So it's now my privilege to introduce the session and our panellists for today. Dr. Elise Bant is a Professor of Private Law and Commercial Regulation at the University of WA, a Professorial Fellow at the University of Melbourne and Fellow of the Australian Academy of Law. Elise also acts as a specialist consultant to HFW Australia. She's a general editor of the Journal of Equity, and her main areas of teaching and research interests lie in the fields of unjust enrichment and restitution law, contract and consumer law, commercial regulations, civil remedies, property, equity and trust. That's quite a lot, Elise. Elise has been appointed an Australian Research Council Future Fellow to examine corporate liability for serious civil misconduct, including fraud and predatory trading practices. Welcome, Elise, to the panel. We are also very privileged to have with us former Justice Ray Finkelstein KC. He has said that he's happy for me to refer to him as Ray, doesn't like to be referred to as Justice, so thank you, Ray. Ray graduated in law in 1970 and was admitted to practice in 1971. Between 71 and 75, he worked in Melbourne as a solicitor and also as a tutor at Monash University. He was called to the bar in 1975, specialising in equity, commercial and corporate law. He was appointed Queen's Counsel in 1986. Thereafter, he concentrated on appellate work after acting for state and federal governments and their instrumentalities. He was acting Solicitor General for the state of Victoria during 1992. He was appointed a judge of the Federal Court in 1997 and held additional appointments as Deputy President of the Australian Competition Tribunal and Copyright Tribunal of Australia. In December 2008, he was appointed President of the Australian Competition Tribunal. He retired as a judge of the Federal Court and President of the Competition Tribunal in 2011 and has returned to private practice at the Victorian Bar. In 2011, he was appointed Adjunct Professor in the Law Faculty at Monash University. And during 2011 and 2012, at the appointment of the Commonwealth Government, he was the Chair of the Independent Inquiry into Aspects of the Media. Welcome also, Ray. It's great to have you with us. So I'll now be passing over to Ray, who'll be providing you with a bit of context for the discussion that we're going to have today, followed by Elise, who will take you through the concept of systems intentionality. Thanks, Ray.
Thank you very much. It should be obvious from the title of the seminar, Old and New, what part I'll be taking. I'm going to just give you a brief rundown on what the old view was on how you formulate and discover the intention of a corporation. The courts have been struggling with the concept for years and starting with the proposition that the corporation is an abstraction. It has no mind of its own, and it has no body of its own. But there are at least two significant areas of the law where the company has to be given a mind. For many, many years, for centuries now, it's been accepted that companies can be guilty of criminal offences. And on the civil side, we have what are referred to as the intentional torts. Assault, trespass, and fraud are the most obvious. So that both for criminal law, where for serious crime, intention, mens rea, is an essential element, and for the intentional courts, intention is an essential element to discover. So what have the courts done about that? The basic rules of the common law was that some person's mind can be the surrogate mind of the corporation. There are really two theories that have been developed. One which was called the organic theory, and is that a person's acts will be the acts of the company, and the person's knowledge will be the knowledge of the company, if that person can be described as, or can be characterized as, the embodiment of the company. That is the operating mind and will of the company. The second theory of attribution is what's been commonly referred to as the agency theory. It attributes, under this theory, the corporation is treated as having acted and as having the knowledge of a person who is acting, I use a quote, within his appropriate sphere. It includes agents and employees who can be said to be the directing mind or will of the corporation, provided they are acting within the scope of their authority. One factor that has to be examined very carefully in these sorts of cases is identifying the right people to see if their mind and their conduct is the mind and conduct of the company, is a detailed analysis of the organizational structure of a corporation to see whether the people are the right ones or not. In other words, the analysis is an inherently factual analysis. The courts have tried to put proper boundaries around the theories, and in recent times they've tried to develop overarching principles rather than sort of ad hoc discussions about who is or who isn't the mind and will of the company. And there's a Privy Council decision called Meridian Global, which sets the basic framework. It has what it now describes as primary rules of attribution, and that requires identification, usually from the company's constitution, who are the people who effectively speak for the company, and most times it's the board of directors. Then there are the general rules of attribution, which looks at servants and agents, people acting in combination, who should be regarded as speaking for and acting on behalf of the company in all relevant respects. It's a bit like the agency theory, or it's a more structured formulation of the agency theory. So that's the old. Elise, on the other hand, is part of the new. She's been developing a very interesting theory about how you can give companies intention and attribute to it conduct the acts of those who are within the organisation. And I'll ask her to introduce that side of it, i.e. I've finished with the old and we now move on to the new.
Thank you very much, Ray. Yes, my theory of systems intentionality builds on the very good work that was done in developing Australia's novel and distinctive conception of corporate culture. That idea has become very familiar to many of us and has its expression in the Criminal Code section 12.3. That idea of a corporate culture reflects the idea that there sometimes is the need to understand and identify a corporation's organisational blameworthiness on its own account. So that is, rather than simply looking for an individual whose mind, for example, knowledge and intention can be attributed to the company, it's better to understand the corporation's wrongdoing through the lens of its own blameworthiness. Now, how can we do that? The corporate culture provisions, unfortunately, haven't proven very successful in practice. So my aim has been to develop a workable, practical model which can tell us when a corporation taken on its own terms and understood as being more than the sum of its individual parts should hold responsibility for acts that require a guilty corporate mind. So how have I done this? Well, it's really simple, actually. Looking sideways at cognitive science, humans like you and me frequently make use of external decision supports that help us to achieve our purposes. So some might be a map or directions on a map, which tell us how to reach our desired destination, a recipe book, which tells us how to achieve our desire to bake a cake, or a notebook, which reminds us of how to do some particular task. Next slide, please. Now, the trick is with corporations, they don't have a natural mind. And so everything that they do must be achieved through decision-making systems. Now, some of these are, come with the territory, if you like. You can't have an active corporation, for example, without having some basic rules around a board of directors, the decisions of which count as the decisions of the company. Without those kind of basic systems of conduct, a corporation would be inert. It would be a zombie company just sitting there doing nothing. But of course, not everything can be done through a board of directors. The everyday intentions and purposes of a company need to be set out in ways that can be or need to be facilitated in ways that allow a corporation to operate on a daily basis. And my basic idea is that systems, and this is the idea of systems intentionality, is that corporations manifest their state of mind through their systems of conduct, their policies, and their practices. So just like when I'm making a cake by applying a recipe system of conduct, and you can look at the system of conduct that I'm deploying and understand my intention and also my knowledge. I know what whisking is, and I know how to fold flour and eggs and so on and so forth. Just as you can assess my state of mind from the system of conduct that I deploy, so too can we assess a corporation's state of mind through the systems of conduct that it deploys. So this is a very simple idea, and it has profound ramifications, I think. Next slide, please. So the key takeaways from this model is the obvious point that systems are inherently purposive. They coordinate and connect steps and processes to some end, whether it be coordinated conduct or to some more specific outcome. Also, as my cake example shows, knowledge of certain matters will be implicit in the successful deployment of a system of conduct. I have to know what self-raising flour is if I'm going to make the cake work. If I achieve my outcome of successfully deploying the recipe system of conduct, we can deduce from that that I understand the ingredients and the steps that are required to produce the outcome. So too with corporations. For example, ASIC and National Exchange involved a predatory business model that could only be profitable if a certain class of vulnerable consumers existed and was successfully taken advantage of through the offer that was made in that case. Knowledge of the existence of this vulnerable consumer group was implicit in the very business model that was deployed. Now, I'm going to stop at this point, but I do say that do draw your attention to my website, which contains some really interesting materials about this model and which I'll return to as we go through.
Thanks, Elise. I really like your analogy of the cake, actually. Corporations as cake. I think that could be something we might see in a judgment perhaps sometime soon. But those sorts of ways of explaining things are really helpful to our participants, I think, because it really makes it clear as to what we're dealing with. Ray, I wanted to talk to you about some of the challenges that you faced as a former judge and commissioner in, I guess, trying to determine corporate culpability. What are the limits you've come up against? And I guess the traditional approaches you talked about earlier, how have you applied those and how have they potentially fallen short for you?
Yeah, that's an interesting question. The problems are really manifold. There are often easy places to look to see who is really guiding the company. So you start off by looking for the board of directors or the CEO or general manager. And if any of those people are involved in the particular wrongdoing that's under investigation, the task is simple. It stops being simple when you deal with typically large listed corporations where there are thousands, if not tens of thousands of employees. And not only are there thousands or tens of thousands of employees, but groups of them, rather than individuals, are engaged in the conduct which is being investigated. This creates an immediate difficulty for a lawyer and for a court. When you attribute knowledge from the officers of the company or the employees of the company to the corporation, what you're not allowed to do is put together what might be the knowledge in the mind of one person and the conduct of another person and say, therefore, the company has engaged in conduct which it knows to be improper or illegal or whatever it might be. A typical example, I've come across this lots of times, is an employee of the company whose job it is to write up the advertisements or make public announcements, whatever it might be, prepares the advertisement, publishes it to the world at large. A company might publish it on the ASX in compliance with its listing obligations, and the board know that the information that's being published is false. Can you put together the conduct of the person who had undertaken the task and did the act, which is perfectly innocent and perfect, I mean by that, perfectly honest, and say the corporation knows that an innocent act is taking place, but the other side of the corporation knows that it's dishonest. Now, up until now, there are very rare circumstances where the law can allow a claimant, whether it's a prosecutor or a party claiming a civil action, to put together the act on the one side and the state of mind on the other and say, there, I've got the company, it's responsible for the act, and some other part of the company knew that it was illegal, and therefore it's culpable and can be found liable. It's a sort of double-pronged or triple-pronged problem. Finding the people who engage in the conduct, and when there's thousands of them, go find them. And you should assume, as is the case, the corporation doesn't cooperate very much, and then trying to piece together a structure which is acceptable and within the limits of current principles that allow you to carry out the attribution. And it comes about sort of in every day. I did a commission where I had senior officers of the company who were able to, probably quite legitimately, say, we did not know this was happening. It was not our responsibility. Now, there might be some other argument to say ducking responsibility is itself a problem. That's not the problem that we're dealing with now. But large organisations, people in large organisations can easily say, we don't know. We rely on groups of people to advise and to act, and that makes the task of tracking it all down and shooting home responsibility to where it lies extremely difficult. And I must say, frustratingly difficult. And I know an obvious question is, what can you do about it? And sometimes the answer is very little. Parliament has tried to come to grips with this, because in various pieces of legislation, Companies Act on one hand, the competition legislation on the other, and there are plenty of other examples, make express provision saying that companies shall be liable for the acts of certain named individuals, a bit like an agency problem, so that the Parliament has recognised that the task of the courts is exceedingly difficult, and they've effectively tried to help, not by supplanting or replacing the principles that the judges have developed, but by adding to those principles to make life simpler. So then you can say, well, I've got an employee, he was acting within his scope of authority or her scope of authority, and that's all I need to fix that person's conduct and that person's mind as the mind of the company. But that's really saying, I suppose, that the legal system struggles with the problem and needs the aid of Parliament to help fix it. And a live question is whether Parliament is really the ultimate solution, or whether the kinds of theories that Elise is developing can be an adjunct to or to the existing norms of legal thought and make perhaps parliamentary intervention, which is always very difficult to get, try and get an act of Parliament passed. Only certain people can ring up the Prime Minister and say, I really need this. So it really means that the court system has to develop itself to make proof much easier in an ever-increasing complex world. When you had a mum and dad company run by two people, it wasn't a problem. When you've got an organisation with 50,000 employees, it is a huge problem. And the current state of legal principle needs assistance, not just from Parliament, but from developing new thoughts and new ideas, which may be adopted, or at least have the capacity to be adopted. I'd be interested to hear what Elise thinks about that.
Yeah, and so Elise, we've heard all about the limitations and the difficulties, and things are evolving where everything's undertaken by these faceless corporations. Systems are running the world. So what do you think the answer is from your perspective?
So I think that Ray is absolutely right that a key question is whether or not there can be change that can evolve in our way of treating corporate responsibility that can evolve organically within courts, or whether we need judicial intervention. I'm a bit of an optimist. I think that we can build on insights that we already have currently in our legal system. So, for example, there is a very powerful prohibition on unconscionable systems of conduct under the Australian Consumer Law and the ASIC Acts. That builds on itself judicial insights into corporate practices, and it gives us a very strong idea of how systems of conduct bear on corporate mental states. Also, really importantly, practical things about how one goes about proving the existence of a system of conduct. How a system of conduct looks different from high-level policies that are implemented. what about practices that develop organically from the ground? So this is a rich source of jurisprudence that I've drawn on in developing my model, and which provides some real teeth and some workability around the model, I think. I'd also say that, Ray is absolutely right that as soon as you deal with larger corporations where knowledge is fractured across teams, as soon as we're hinging corporate responsibility on individuals, even a wide net being cast over employees operating within their scope of their employment and so on, and attributing that to the corporation won't sometimes do the job. And of course, the Crown Casino had some really good examples of that, that Ray had to deal with when he was the Royal Commissioner. Just one example, the Crown Casino AML processes, anti-money laundering processes. No one at board level knew of the problems with the anti-money laundering AML processes. Bad news did not have a tendency to travel up, even when banks were busy shutting accounts over fears of those accounts being used to facilitate money laundering. That information apparently did not make its way to the board. Now that may be for legitimate reasons, that is, may not have been a deliberate ploy, but nonetheless, on a traditional approach, that kind of information silo and information sealing is very effective to reduce corporate responsibility for the misconduct that in fact occurs. Within Crown, there were two teams that dealt with money laundering. There was the cage staff that took in information about deposits that were coming into the corporate group, and the anti-money laundering team. Now, the anti-money laundering team had to have access to the information that the cage staff were taking down in order to be able to spot suspect transactions. Unfortunately, the cage staff had a long-standing practice of aggregating information about deposits that was coming in a way which completely ruined any chance of the AML team being able to spot money laundering. Now, this was a guaranteed outcome of the way in which those two teams operated, the way they were structured, the fact that there was effectively information barriers between them. There was never any audit or even discussion between the AML team and the cage staff about how the one's practices would affect the other. And this was Crown's own system that was rolled out over generations of employees. Cage staff picked up these practices because they were trained how to do their jobs. So this was Crown's own system. So the point that I made in my submissions to the casino, and which was discussed in the final report, was that on one view, through the lens of systems intentionality, how these systems were set up said something really profound about Crown's state of mind. That is that, this was intended conduct. These were systems that were patently on their face interdependent, and yet they were guaranteed not to be effective to prevent anti-money laundering practices. Actually, on one view, they were guaranteed to facilitate money laundering behaviour. In view of this knowledge and the fact that these were intended systems of conduct, Crown's conduct was open to be characterised as reckless and even dishonest. So rather than the fact that the individual cage staff were honest and hardworking, and the individual AML team members were honest and hardworking, rather than that being a way of excusing and diminishing corporate responsibility, instead we look at Crown's own system and assess the culpability manifested by that system. And it gives us an entirely new way, I think, of understanding corporations' blameworthiness in terms that we can all morally understand.
It's a really fascinating example, the casino example, because it's something that I think many of us regulators come across, where you've got good and diligent people working away in systems that have evolved and grown, perhaps like mould, over a period of time, and are producing perverse results But even in circumstances where a person isn't intentionally doing that within the company, it may be that we can infer the intention by what's coming out of that system or the design of that system. I just wanted to go to some of the Q&A because we've got a few questions here popping up from our viewers. So Jonathan Southerland says, great presentation, Elise. Read your explanation. This assists when we require a guilty corporate mind. I assume you don't mean guilty in a legal narrow sense, i.e. mens rea, but your framework also assists when considering reckless or other degrees of association with an impact, which I think you've just touched on already.
So I do, I certainly don't mean guilty as in a determinative final outcome. My analysis is designed, though, to enable us to understand what a general intention and what a specific intention, what knowledge, what mistake looks like when thinking about corporate systems of conduct. So how do systems of conduct manifest these specific states of mind? Then you can use those mental states to help make normative assessments. So in light of that knowledge or in light of that intention, do we understand certain conduct as being reckless or dishonest? Now, of course, those, or unconscionable for that matter, those normative standards are mixed standards of objective assessments of the quality of conduct assessed in light of the corporate actor's knowledge and intention. So we need to be able to, we need to mind read the corporation. And the beauty of systems of conduct is that when you assess a systems of conduct that has been adopted and deployed by a corporation, the corporate state of mind is out there for everyone to see. And this is the thing that came out so powerfully from Ray's review of the Crown systems of conduct, that, the glossy websites said, we have a certain, set of values and so on, but the reality demonstrated through their systems of conduct was a profit at any cost value.
Yeah, that's really interesting. And I think something I might address to Ray, actually, considering your experience as both an advocate and a judge, is how do you think we as regulators, and I guess more to the point, enforcement investigators in that context, how can we use systems intentionality to build evidence on corporate misconduct? How should we take that into account when putting together our investigative strategies?
I think it's necessary to draw a distinction between, on the one side, true criminal cases, and on the other, civil cases, because the principles and the use of Elise's theory will differ fundamentally depending on what side of the legal system you're on. I think that the main benefit of the systems intentionality approach is when it is necessary to identify deliberate conduct rather than the subjective mind of the actor, including a company actor. It may be possible in some circumstances to identify a system which those who designed it, or more importantly, those in the corporation who put the system into allow the system to be put in operation, knowing what it can do, if the system itself is likely to cause harm, or to cause misunderstanding, or to cause deception, or whatever it might be, then it's easy to say that the corporation, through its authorising mind, that is developing and allowing the system into the marketplace, which objectively is known to cause some kind of harm, are responsible for it in an intellectual sense as well as a moral sense, and therefore in a legal sense. In a criminal case, though, that won't work. In the criminal case, when you're looking at the subjective intention of the actor, and sometimes that when you're looking at a corporation, you have to look at the subjective intention of a person who is going to be attributed as the mind of the company, that won't work. Because they need an actual dishonest intent. So you can really, I think, put to one side the criminal sphere, except to this extent. When it comes to punishment, these issues will loom large, because as the sentencing judge will always tell you, the more deliberate harmful conduct is, I mean by that, the more deliberate illegal harmful conduct is, the greater the penalty that will be imposed. So that will be, I suspect, the limit of its role in criminal cases. It has the same parallel in the quasi-criminal cases as well, when ASIC moves to, on the civil side, to impose penalties under the Corporations Act, or ACCC does it under the Consumer Act. So the courts always look on the imposition of penalties to how serious the conduct is and how deliberate the conduct was. So that if you set up a system which objectively causes the harm, and you have and the system is structured by the company, so it doesn't accidentally come into existence, but it is created by the company as part of its business operations, it'll have enormous impact there. And then there are those areas where intention on the civil side doesn't matter, but deliberate conduct does in the unconscionability side. There you might only look at the objective features of what has happened and resolve the issue by looking at the objective conduct, the consequences of that conduct, and ask, is that unconscionable or not, as the law would see it. So it has a significant role to play there. So it's really saying that from a regulator's point of view, you would look at the issue on the civil side for a variety of reasons. You'd leave it alone on the, I think you'd leave it alone because you won't get much use out of it, on the criminal side when you're looking at mens rea, when you're looking at what is the intent, what was the subjective intention of the act, was it to carry out the illegal act or not. So you have to be very careful, and I think you have to be very careful that you don't slip from treating deliberate conduct the same as intentional conduct, in the sense that the law requires intention as an element of certain criminal and certain civil offences. So it's sort of a note of caution. I think they'll have much more value when the conduct in question can be wholly objective, i.e. you don't care what people think or do or why they do it, but if you're looking at what actually has happened, then analysing systems to explain what has actually happened, and you can usually work out why it's happened as well, then it's most valuable. In fact, it might be the easiest place to begin when you're analysing conduct, especially conduct that affects very many people.
And I think certainly in the civil penalty side of things, I can really see an application, and even in my own work, and no doubt many of the people watching today, because that's one of the factors in terms of how you might assess a penalty or submit to the court that it might be higher or lower. And with many of these systemic cases, like if you look at ASIC's bank fee cases, or even my own agency's case against Origin Energy with its hardship program, none of these systems were intended to rip people off or treat them inappropriately by anyone in particular, but the result was a poor one for consumers. And so if you look at it objectively, you can see that, but if you look at the particular people involved, it's a little bit different. So it might be interesting to see if any of our members start making submissions of this nature when bringing their penalty proceedings. But look, I might head to a bit more Q&A because the questions are coming in thick and fast. I might direct this one to you, Elise. Are you able to comment on the utility of the model in the case where corporate culture results in general knowledge within a company that goes along the lines of that policy is only to tick a box, we don't actually follow it fully?
Thanks, that's a very good question. And again, this is something that came up repeatedly in the Casino Royal Commissions, that you can have a corporate culture that effectively encourages employees, if they have a choice between, for example, a more costly but compliant approach to engaging in some task, or a much cheaper approach that promotes profit, and that's really the value that the corporation holds dear. Corporate culture can have a strong influence in effectively encouraging unlawful or contravening behaviour on the part of employees that are embedded within systems of conduct. Now, from my perspective, corporate culture is really probably closest to being understood as a form of high-level corporate policy, which tells employees that are engaged in sort of day-to-day, more granular systems of conduct, how they should engage in the sort of tasks that form their everyday behaviours. And if you have a delinquent corporate culture, for example, a policy at a high level which says profit at any cost, you won't get promoted unless you make sure that you keep the gamblers at the pokies, you know, for as long as possible, your job is to encourage that, and so on, then that will be very effective at prompting, you know, unhelpful, harmful, granular systems of conduct, whatever the formal, you know, processes and procedures and training and so on says. So you can have corporate cultures or corporate policies that undermine and really give lie to formal, glossy, best practice type standard operating procedures and so on. And so it's really important when you're thinking about systems intentionality and you're thinking about what corporations are saying about what they're revealing about corporate mindsets, that we look at the systems of conduct as instantiated, as deployed, as rolled out on the ground. Those are the ones that actually reveal or manifest the corporate state of mind. Where you have glossy systems of conduct or policies that state to the contrary, that they, you know, emphasize, you know, good practice and so on and so forth, they can simply be regarded as misleading as to the true corporate state of mind. So it's a really good question, and I hope that's addressed it somewhat.
Yeah, and another person has raised a similar issue about where the documentation would actually mask the real purpose of an organisation, where the theoretical is opposed to the practical. And I think as regulators, and more particularly enforcement people and investigators, we do come across, oh, look at our UBUT, you know, policy here, and here's the script that we follow. And it's only when you dig deeper and you start actually finding out, oh no, the real policies or the real way we do things around here is like this. But I guess that in effect can be a far more challenging job for a regulator in terms of discharging those types of investigations, because you have to negate what they say they do with what they actually do, and a lot more witnesses are required.
There might be some easy examples, though. Take, and I saw this with Crown, but it must be commonplace. Often people's remuneration is structured in a way that will result in specific behaviour. So if I get all the car dealers or whatever the official position is at a casino, and they get paid on the customer's turnover. So you know that they are necessarily going to encourage turnover. And the more they encourage, the more profit is made, but the more harm is potentially caused. So, and not only is the method of remuneration likely to cause particular behaviours, it would be known across, I was going to say the company, but across the industry, that particular kinds of rewards will necessarily result in particular behaviours going to be engaged in. And if they're harmful, then it might not be a short step to say you intend what are the either logical or inevitable or likely consequences of a system. So there's nothing in that it's saying, I'll pay you a commission based on turnover. But in a particular industry, if I pay you a commission based on turnover, which is perfectly rational, perfectly common, but if I do it in a situation where the person to whom I'm paying is likely to engage in unreasonable, unfair, predatory conduct to increase their remuneration, then it's not a long step to say the person who's devised the method of payment should be responsible for the consequences. And not only that, knows the consequences. If they're the likely consequences or the most probable consequences, then why shouldn't you be deemed, and the law, I think, will probably say you should be deemed to have knowledge of those consequences and pay the price, whatever it might be. So it doesn't have to be at all complicated. And it's as simple as saying, look at a contract, here's pay rate. And you look at the contract, it looks ordinary, straight up and down, traditional method of rewarding an employee for their services. Until you look at the setting in which it happens and say, well, this is going to happen, this is not so good in this setting.
And just sticking with you, Ray, like, do you think the discussion has changed since the Casino Royal Commission at all?
Lawyers are an inherently conservative group of people. I am doing a piece of work at the moment, and I have been looking backwards, i.e. I've been reading cases decided in the 1600s and 1700s as a source of inspiration. It is very hard to think that the legal system is going to change radically quickly. It's not happened in the last 400 years, and it's not going to happen. We are a backward-looking profession. That's where we get our principles from. I think that there is a realization amongst courts that there has to be a change. And we see that not only in the areas that we're talking about, but when industry changes, when methods of doing business change, when technology changes, when the world gets more complicated, the law inevitably tries to catch up. And in the catching up process, things will be looked at differently, and old models discarded and new models adopted. It's just an exceedingly slow process.
And developing new models is why we need people like Elise on the job. And so, Elise, what's your perspective on that?
Well, I think that we have seen some movement, actually, just within the case of Crown Casino. The Bergen report really focused very heavily on the members of the board, senior management, and so on, and really tethered the idea of Crown's own suitability to act as a holder of a casino license to the suitability of those persons. And so there was this very individualistic focusing on the heads of the corporation. When Ray's commission started, there seemed to be, from my perspective, a quantum shift away from simply looking at board renewal to understanding that in order to be a suitable corporate person, there had to be fundamental changes to the corporate systems of conduct, policies and practices as embedded on the ground. And that was a huge shift, I felt. It was one that was endorsed subsequently by the Perth Casino Royal Commission, and you find again examples of it in the Star Casino, where there's this understanding that it's not good enough. It certainly helps to have good people occupying top positions. That's also, of course, very helpful. But it's not going to do the job on a day-to-day granular level if business just continues as usual. And that has very significant ramifications, I think, for corporate resourcing, for example, of change. You know, to introduce new ways of being on a day-to-day basis, to change your everyday systems of conduct that really, reveal the corporate purposes and values and beliefs and intentions. To do that requires time, and it requires resources, it requires training, it requires training of the trainers, It requires there to be audit and remedial processes so that systems that are introduced can be monitored and remedied when they, if in the event that they bring about harms. So it does require different mindset. I think Crown very quickly twigged to that, really, from the opening day of the Victorian Royal Commission. They twigged that it wasn't going to be enough to simply, have board renewal. Something else was going to be required, and the size of the task became apparent. I think that the sorts of orders and recommendations, rather, that Ray and Perth Casino Royal Commission made are sort of indicative of what needs to happen if you're going to have rehabilitation of a corporate citizen, and provide some really useful templates about, for what regulators and courts can both do to affect some real change.
And what you say about, it's about an overhaul as opposed to the board renewal, I think is right, because if it's systems intentionality, the problem is with the system potentially, and that's what needs to be overhauled. Ray, you were going to say something.
Yes, I was going to just add to Elise's point. There will be a change in the way big corporations do business, but I think that one thing that will happen relatively speedily in the courts is they will have a relook at the responsibility of directors. And I think one thing that the various commissions have identified is that the oversight responsibilities were considerably lacking. The oversight, in many respects, was almost non-existent. And I think it's not a big step for courts to look at what are the overarching responsibilities of a board and say it's just not good enough to say, I've got a great CEO, I'll leave it to the CEO, I've got a great manager, I'll leave it to them. I think the courts will move significantly towards imposing greater oversight responsibilities on the board, and oversight not only of personnel, but oversight of the methods of doing business. And I don't think you really need lots of red flags to say this is the area that we now know we have to look at because something's gone wrong. I think the courts will shift quite soon to say you should see that whether things are going wrong or potentially might be going wrong, and you start looking at them. So I think in the area that we've been looking at, where we're looking at both the behaviour of personnel or the systems that corporations have employed in order to further their business interests, that they will end up requiring the board, who's ultimately responsible for the company's conduct, to look very carefully to make sure that the personnel are functioning properly, the systems are functioning properly, and things aren't going awry. And in the end, although it's quite right to say that it's not the board's responsibility all the way through, the whole organisation has to function properly. Sooner or later, the people who say they are in charge of the company will be made to bear the responsibility for things going wrong. And I think so they should.
No, very good point. Just sort of moving to a close, Elise and Ray, it'd be good to get from you any insights you might have from all of our regulators watching here today regarding systems intentionality and how you think they can bring this kind of thinking to bear in the work that they do every day. Elise, what are your thoughts?
Well, I think that regulators are actually at the forefront of changing behaviours as well as upholding the rule of law and the application of community standards and so on. I think that systems intentionality enables regulators to ask a different set of questions of those entities that come before the regulator for, suspected misconduct. It allows regulators to ask probing questions that go beyond just the glossy front page of a corporation and the people that occupy the top positions, to actually drill down into the reasons why misconduct has occurred and be able to assess those reasons, and to be able to put make some decisions based on the reality of the corporate misconduct. It's important for considering what kinds of actions to bring, whether to proceed administratively, what kinds of contraventions may have occurred, but it also enables regulators to set the tone around what's required for a corporation to make good its misconduct. So I think it's quite a powerful and practical tool. I hope so, certainly, and indeed, certainly the company directors and officers that I've spoken to about this model, they understand what its implications, and being very familiar with the idea of corporate culture. This is not a big step, it's a natural progression, and I think hopefully it should be relatively easily understood.
Well, that's good. And Ray, what are your thoughts?
Well, looking at it from a perspective of the court system, I know that changes in approach are never radical, but incremental. And I think from a regulator's perspective, it requires some planning how, on a step-by-step basis, the way that the courts approach decision-making in these areas can change. So it's really starting to build up, saying, well, we're only looking at whether this conduct is acceptable. We're going to look at whether this conduct is deliberate. Once you've got a series of cases saying, well, of course, we're going to go at the deliberate conduct, and it's relevant when deliberateness is at play or a relevant issue. Then we go to the next step. Is it also conduct, the consequences of conduct known or likely? And then we work out a set of principles that will dictate what will happen when a corporation engages in conduct where the consequences, the adverse consequences, are likely. And then the next step is, and should those likely consequences be known to those who run the corporation? Or can they turn a blind eye? And then we say, well, we all know that turning a blind eye is the equivalent of actual knowledge. Can we structure the arguments so that the directors or the board is really turning a blind eye, that's actual knowledge, and the board of directors that necessarily fixes on the company? So that it requires detailed planning and lots of thinking about how, but as long as it's done on a step-by-step basis, I'm sure that it will have an effect, an important effect in changing the way courts look at dealing with very large corporations.
Thanks, Ray. And look, we've come to the end of today. I think it's really been a fascinating discussion with you both. And I've now had a couple of these discussions with you, and every time I take away something a little bit more. There's been a lot of questions coming through the Q&A that I didn't have a chance to ask, and also a lot of people really appreciating the perspective you put forward and the presentation. So thank you so much for your time, Ray and Elise. It's been a really interesting discussion. And to everyone watching, a reminder that the recording of this webinar will be available on the ANZSOG YouTube channel. So your colleagues who missed out on the fascinating presentation can still watch it. And you can see there's all the hand claps going up the screen. So you've got a bit of applause there, which is good. Please also look out for our feedback survey, which will be sent out this afternoon on the steering committee for the National Regulators Community of Practice. We do look at these results and try and feed them into our next offering. So we really value your feedback. Look out for our next webinar, which is a hybrid one. So in person and online, very exciting. And it's in Brisbane, which is good for me because I live there. It's on the 15th of November at 12 p.m. Brisbane time, 1 p.m. daylight saving time. If you are from other sites, you can join online. It's entitled Having Your Say versus Getting Your Way, Why Good Regulatory Comms Matter. And we've got a really fantastic panel of people that are really experienced at this. The seminar will be followed by a lunchtime networking session, which I'm really looking forward to. Thanks for joining us, everybody. Goodbye now.